Greetings and salutations, my fellow sovereigns. This is the Vocational Science of Freedom Saturday Night Civics and Sovereignty class, and tonight we will be continuing our reading from a Dueprocess treatise. If you'd like to join us, you can do so by going to Rumble at VSOF. We're also on Odyssey at VSOF:8, and we're still, at least temporarily, on YouTube until we get kicked off again, possibly. And we are also on Gab. And so tonight, our treatise will be a practical treatise upon the law of judicial writs and process, which we've been going over for the past several weeks. And it is a treatise from 1895, during the heyday of the common law, when it was doing what it was supposed to be doing, before it got stolen from us. And we will be continuing and reading on Chapter 24, which is on page 293 of the PDF. And you can find all of the handouts for this class in the mega link that'll be in the show notes. And if you'd like to join the Vocational Science of Freedom on our Revolt server, you can find the welcome package in all of the About section on all of our video platforms, whether it be Rumble, YouTube, or Odyssey. Just click on the About section and go to the mega link and download the welcome package. And that will give you the invite to join our Revolt server and also get you set up with our secure comms to join us on Mega. Okay, so as we left off, this will be the service of process in a state other than where issued. So we're going to talk tonight about service of process on non-residents, how that affects jurisdiction, the effect of personal judgment rendered on service in another state, and service in another state in proceedings in rem. And again, in rem means court cases against a thing, a res. So section 110, service of process on non-resident. That a resident of one state may be subjected to the jurisdiction of the courts of another while temporarily in the latter is well established. Service of process made on a non-resident while in a state where it issues will support a judgment in personam. Okay, now what is in personam? And if you guys want to open up from the show notes in the mega file, I have a Word doc that goes along with this class and it has all the definitions in it. So we're going to be going and looking at in personam. Now, these definitions, unless specifically stated so, meaning like this one says Black's Ninth Corporation, Black's Ninth, and litigious, will be from Bouvier's Law Dictionary, the 1856 edition. So this is what we'll be reading from as far as in personam is concerned. So in personam, remedies. A remedy in personam is one where the proceedings are against the person in contradistinction to those which are against specific things or in rem. So that's what an in personam judgment is, against the person. So to continue, in a main case cited, it is said, quote, he disputes the jurisdiction of the municipal court upon a plea that he was not a resident of any place in Hancock County, but had his residence in Boston in the Commonwealth of Massachusetts. We think he was a resident in Eden in the meaning of the act creating the municipal court while personally present there, and having at the time no permanent home or residence anywhere else in this state. His bodily presence there was, for jurisdictional purposes, equivalent to residence. His permanent domicile, and I'll get to domicile in a second, may have been in Massachusetts, but his domicile for the time being, his transitory domicile, was in Maine. And he was in a cormorant, and I had to look that one up, which we'll cover in a second as well, of any place found. If it were not so, then none of our courts have jurisdiction of defendants who are non-residents of the state, but are personally present within its borders, for the statutes do not provide for such cases. Okay, so we have this difference between a residence and a domicile. So domicile, and this is a fairly lengthy definition, I'm not going to read all of it through, but it's important to know the difference here. So from Bouvier's domicile, the place where a person has fixed his ordinary dwelling without a present intention of removal. The law of the domicile is of great importance in those countries where the maxim actor sequor forum re is applied to the full extent. Number 2, a man cannot be without a domicile, for he is not supposed to have abandoned his last domicile until he has acquired a new one. And just to make a point here about domicile, you can only have one domicile, but you can have many residences. And the aspect of a residence is that you're there temporarily doing business. And when you're done with your business, you'll go back to where you came from, which is your lawful domicile. So to continue here with the definition, through the Roman civil law, a man might abandon his domicile, and until he acquired a new one, he was without a domicile. By fixing his residence at 2 different places, a man may have 2 domiciles at one and at the same time. Now, again, just remember, this is under Roman civil law they're talking about here, not at law or common law. For example, if a foreigner coming to this country should establish 2 houses, and the establishment of a house is important, one in New York and the other in New Orleans, and pass 1/2 of the year in each, he would, for most purposes, have 2 domiciles. But it is observed that circumstances which might be held sufficient to establish a commercial domicile, right? What's that? Well, that's a residence. Okay. In time of war, and a matrimonial or forensic or political domicile in time of peace might not be as would establish a principal or testimoniary domicile, for there's a wide difference in applying the law of the domicile to contracts and to wills. So they get into, later on here, they get into the aspects of what these different domiciles are. So you have a domicile by origin is understood by a man's home of a man's parents, not the place where the parents being a visit or journey, a child happens to be born. So if you're born in a state, you're a de jure state citizen. Domicile of origin is to be distinguished from the accidental place of birth. There are 2 classes of persons who acquire domicile by operation of law. Okay, so you have domicile of origin and you have domicile by operation of law. 1, those who are under the control of another, right? As in an infant or a lunatic, right? And to whom the law gives the domicile of another. Among these are 1, the wife, 2, the minor, which is extremely important, 3, the lunatic. Those on whom the state affixes a domicile, among this class are found the officer, number 1, and 2, the prisoner. Okay, so why am I even reading this? Why is this even important regarding a domicile? Take, for example, the aspect of property tax. Okay, so you have all these different classifications of property tax, and they all, and one of them is a residence. So you have commercial land, you have agricultural land, you have industrial land, and then you have a land classified by, oh, that's residential. Okay, because they're classifying all of the land that's quote unquote have to pay property taxes where you're staying at considered residential land, it's not considered a domicile. And you can see this in various different states, particularly Florida, where there is a homestead exemption. Your homestead is where your domicile is. Okay? So what they're doing is they're considering you to be a resident. And it's very important to understand this because their presumption is that you are a resident of the District of Columbia. Okay? Which we covered in previous classes. And we'll get into some more presumptions about that regarding federal jurisdiction later on this evening. But it's really, really important that everybody understand the difference between a residence and a domicile, okay? Because it's how they trick you into the jurisdiction of their courts. So, and then to continue here, well, I'm not going to read the rest of this, but from the standpoint that there's understanding that there's a temporary residence at various different aspects, but you can only have one domicile. As it says here, the law affixes a domicile. Public officers such as the President of the United States, the secretaries, and other such officers whose public duties require a temporary residence in the capital. What's the capital? D.C. Retain their domiciles. meaning wherever the state is, the actual de jure republic of where they're from. Okay. Ambassadors preserve their domicile, which they have in their respective countries, and this privilege extends to the ambassadors' families, period. Officers, soldiers, and Marines in the service of the United States do not lose their domiciles while thus employed. 2. A prisoner does not acquire a domicile where the prison is, nor lose his old. So why did I put that in blue? Require a temporary residence at the capital. Because when you're considered to be a public official, right, and the definition, the proper term really under the United States Code and how they use it in the IRS codes is called not a public official, but a federal personnel. They deem it to be a federal personnel. And who is federal personnel? Basically anybody who has a social security number. And if you're considered to be federal personnel, then that's where they get you in this aspect of being a officer of what? Of DC, that have a temporary residence at the Capitol. That's the presumption that they're using, okay, against you. So I'll leave domicile where it is here, and we'll get back to the treatise. So his bodily presence there was for jurisdictional purpose equivalent to residence, his permanent domicile, so on and so forth. All right, commonwealth, what's that? One residing or inhabiting a particular place. If it were not so, then none of our courts have jurisdiction of defendants who are non-residents of the state, but are personally present within its borders, for the statutes do not provide for such cases. Again, all persons found in the limits of a government. Now, notice it says persons, not people. So all persons found in the limits of government, whether the residence be permanent or temporary, are to be deemed subjects thereof. And I'm not going to get into the definition of deem, but deemed is basically an aspect of presumption. They're presumed to be subjects thereof. The true interpretation of the principle is that when an alien or non-resident is personally present in any place in the state, however temporary or transitory in such place, whether abiding, visiting, or traveling at the time, a process duly served upon him will confer complete jurisdiction over his person in our courts. The exception to the rule thus announced concerns the presence of non-residents in a state under circumstances which exempt from the service of process, which will be the subject of the following chapter. The power of the courts of one state to subject citizens from another state to their jurisdiction by the service of process in the latter, and the rendition of judgment in personam is the subject here to be discussed. So in personam, against the person. There's, like I said, a big difference between in rem judgments and in personam judgments. Okay. And okay, so section 111, effective personal judgment rendered on service in another state. The consideration of the question may be properly introduced as its answer given by the statement that the life and force of process is restricted to the territorial jurisdiction of the court from which it emanates. By statute, the service of process made in any part of the state where it issues may be and is valid. But it is beyond the power of the people of one state to give validity to a judgment in personam rendered on the service of process in another. Okay, so this is the subject of tonight, and it's not initially like logical from a standpoint of, okay, you get court process and you have to go to court. There's a big difference between the power of the people of one state to give validity to a judgment in personam rendered on the service of process in another. So you can't be subject to the jurisdiction of a foreign state unless you willfully go there and waive any argument that you might have to having been served in your state when it's another state that's coming after you. Okay. And the only time that this changes basically is in an in rem action. Okay, which we'll get to later on. So we have various different aspects going on here. One, the different jurisdictions. Is it done in California? Is it done in Pennsylvania? Where are the defendants and where are the plaintiffs? Are the plaintiffs starting the case in Pennsylvania? Are they starting the case in California? Where are the defendants? Are they in California or are they in Pennsylvania? And so on and so forth. Okay, so there's these various different things that we have to keep in mind here. Okay, to continue. The judicial powers of a state are bound by state lines. Yet attempts to do so have been made In an early case, Chancellor Walworth had occasion to decide upon the validity of a chancery subpoena served in New Jersey. We quote from his opinion as follows, quote, "From information derived from some of the most respectable solicitors in the city of New York within the first 2 or 3 years after I came into this court, I know they had been in the habit of considering a personal service of a subpoena out of the state as regular. I have also reason to believe my immediate predecessor, tacitly at least, sanctioned this practice, and that during his time many decrees were entered upon the usual affidavits of regularity, which affidavits were founded upon the service of subpoena in the adjoining states. Moulton, in his practice, says, where the defendant resides abroad, service of a subpoena may be made personally. A more recent writer on the practice of this court, after an examination of the cases on the subject, seems to entertain the same opinion. I am not aware of any reported case in which this question has arisen and been decided in this state. In England, the practice does not appear to have been definitely settled, but from the reports, it would seem that the last decision was against the validity of a service in a foreign country. So the subpoena was served in Scotland, and the defendant, afterwards coming to England, he was taken on an attachment for not appearing. The Master of the Rolls was clear as to the regularity of the service of the subpoena, but Lord Thurlow, doubting it, stood over several times, and finally the process was dropped. The statute in this state having provided a mode of proceeding where the subject matter of the suit is within the jurisdiction of the court and the defendant is beyond its jurisdiction, so that he cannot be served with process, there can be no good reason why this court should extend its arm beyond the bounds of the state. And therein lies the whole point. A state can't reach out into another state, grab somebody, and bring them back, okay? Unless, obviously, felony. Because then what happens is that if it's a felony charge and they're in a different state, then what has to happen is what's called a governor's warrant, of which the governor of, say, Pennsylvania signs off on the extradition of the one who the warrant is against back to California. But that has to be done, again, by governor's warrant. But it can be done in the aspect of felony. But what we're talking about here in this chapter is about civil process, okay? To continue, for the purpose of acquiring jurisdiction over the person of the defendant. So it is also wrong in principle that a defendant should, by the process of any court, be compelled to appear in answer to a complaint in another state or country in order to protect himself from the consequences of a personal decree founded upon such process. In all cases, however, where the court has jurisdiction over the subject matter of the suit, meaning the res, the thing or whatnot, or the capacity of the court to bring judgment, if the defendant who is beyond the limits of the state thinks proper to waive that objection by voluntary appearance, meaning he makes a general appearance, or by consenting to accept as regular the service of process upon him at the place where he resides, or is found, he cannot afterwards object to the regularity of the proceeding against him founded on such service. And I made a note here. This is why you never make a general appearance in any matter before any court. Okay? Because the vast majority of the times of which anybody has to, or they think they have to, go to court to defend something, I can guarantee you that due process was not properly followed. So, whenever you find yourself in court, whether it be for a traffic ticket or a mortgage foreclosure, whatever, even a criminal matter, do not ever make a general appearance and do not ever waive your objection to bring up the matter of due process, because due process is a constitutionally protected right. If they violate it, if they do not do it correctly to get the jurisdiction of the court properly established, then the court doesn't have it. That's why the reading of this whole entire treatise is so important, to understand what your due process rights are. That's what this whole treatise is about. And if they don't have it, they can't bring judgment against you. Unless, of course, you voluntarily waive it. If you waive your objection, that's your own fault. Okay? All right, to continue. The Vice Chancellor was therefore right in this case in deciding that the service of a subpoena upon a defendant at Newark, New Jersey, was not sufficient to warrant the entry of an order to take the bill as confessed for the want of appearance, and this being in New York. We thus quote at length from the opinion of the eminent jurist because it clearly and forcibly announces the law upon the subject and has been generally recognized and followed in subsequent adjudications. It is not sufficient that a defendant have actual notice of a proceeding against him. He must be summoned in a legal manner. Now, this is very important, this whole part right here. It is not sufficient that a defendant have an actual notice of proceeding against him, semicolon. He must be summoned in a legal manner. Okay, all these people out here that teach you that, all you have to do is just send somebody something in registered mail and they've got notice and then they're on the hook. Not true. Not true in the least bit. Not certainly from a standpoint of having jurisdiction over them. They don't even have to acknowledge that they got the notice. But if it be summoned in a legal manner, what does that mean? That means that they actually got process served. And I'm not going to rehash process service. We did that last class and the class before that. Ad nauseum, we went over what that is. Okay, so just to take notice of that, you cannot acquire, nor can the court acquire, jurisdiction over someone simply because they sent them a notice in the mail. How often do you find that with traffic tickets? All the time. Okay? To continue. While the purpose of a summons is to notify a defendant to appear and answer a complaint against him, there are essentials attending every service of process which must be at least substantially observed. To be unmindful of this principle will lead to erroneous conclusions. In a Vermont case where the defendant was served with summons in another state, the objection to the service was overruled by the assertion that the defendant had actual notice of the suit against him and an opportunity to appear, and that he could not claim he was damnified. To which the court replied, quote, "This is a good answer to the alleged defect of the return of the officer upon the copy arising from it being written in pencil instead of inked, but the service being made in New Hampshire, it was for that cause invalid, and Davis was not bound to notice it." So make note of that. When are you bound to notice it? When are you not bound to notice it? Okay? When can you tell them, hey, great, I got your notice, but that doesn't give you jurisdiction over me, right? These things are important. Let's skip down a little bit here. A statute of one state expressly authorizes the service of process in another, and the rendition of a personal judgment in pursuance thereof would be violative of the constitutional guarantee of, quote, due process of law, close quote, which is all about the importance of this entire treatise. That right. Process issuing from one state to another fails of its purpose and is a mere nullity. Now, my little note here says, this is telling. I recently had someone tell me of a situation wherein a California court issued an order for a mother to lose her rights to her child when her and her child were domiciled in Pennsylvania. This is clearly a violation of due process and is constitutional as stated herein. So when you get these family courts trying to reach across state lines, tell them to clearly fuck off. Sue the court themselves. These courts do not have a judicial immunity at all. They're all private for-profit courts, meaning they have their own Dun & Bradstreet numbers. They have separate purses from the state, which means they lose any 11th Amendment immunity that they may have had to begin with. Not to mention, the very definition of kidnapping is to take one from one state into another state. So what are these family fucking filthy courts doing? They're all guilty of kidnapping. And, not to put too fine a point on it, they're also guilty of human trafficking. Because they're using the children as an aspect of profit for themselves, which is also called barratry, which is also a crime. Barratry is making money off of the law. You are not supposed to do that, and that is a crime. And that is exactly what every single one of these private for-profit courts are doing. Okay, so understand that and tell them where they fucked up. All right. Okay, to continue. Concerning the validity of a judgment rendered in one state on service of process in another, Mr. Justice Fields has said, quote, since the adoption of the 14th Amendment to the federal Constitution, which is not valid, by the way, it was never properly ratified, but let's just put that aside for a moment. The validity of such judgments may be directly questioned in their enforcement in the state resisted on the ground that proceedings in a court of justice to determine the personal rights and obligations of parties over whom the court has no jurisdiction do not constitute due process of law. Whatever difficulty may be experienced in giving to those terms a definition which will embrace every permissible exertion of power affecting private rights and exclude such as is forbidden, there can be no doubt of their meaning when applied to judicial proceedings. They then mean a course of legal proceedings according to those rules and principles which have been established in our system of jurisprudence for the protection and enforcement of private rights. To give such proceedings any validity, there must be a tribunal competent by its constitution. There must be a tribunal competent by its constitution. That is, by the law of its creation, to pass upon the subject matter of the suit. Okay, to pass upon. What the hell does that mean? Literally, this means to pass judgment upon. Now, you want to be very, very wary of this little statement when you're in court. If you ever hear the judge say, well, I'm going to pass upon XYZ, what he's saying is that he's going to pass judgment upon XYZ. That's what that term means, to pass upon. So, if a judge doesn't have jurisdiction, you're going to want to object to any time that they say that. Because if you don't object to it, and they pass upon whatever it is, whether it be a motion or whether it be actually rendering judgment, you're going to be stuck with it unless you object. Okay? So that's a very important point. This little phrase has never come up before, but I've had to deal with multiple people where this happened to them. And they say, well, I didn't know what he meant by that. Well, that's what the judge means by it, okay? Okay, to pass upon the subject matter of the suit, and if that involves merely a determination of the personal liability of the defendant, he must be brought within its jurisdiction by service of process within the state or his voluntary appearance. So again, he must be brought within the jurisdiction by service of process within the state or his voluntary appearance. It can't be forced upon you. The service of process in a state other than where issued cannot be sustained on any theory in support of a personal judgment. Pretty clear. Such service and all proceedings based on it, so far as concerns any personal liability, are void. The authority of every tribunal is necessarily restricted by the territorial limits of the state in which it is established. Again, that's the whole point of this entire chapter right there. The authority of every tribunal is necessarily restricted by the territorial limits of the state in which it is established. Any attempt to exercise authority beyond those limits is to be deemed in every other forum an illegitimate assumption of power and an encroachment upon the independence of the state in which the defendant is domiciled. Notice, domiciled, not residing, and to be resisted as usurpation. How do you do that? How do you resist usurpation? You sue them. You sue the court itself. Okay. Next section, 112. Service in another state in proceedings in rem. Now, this is where the whole entire thing flips the script. So, on the one side, you cannot do this and expect to have any sort of judgment rendered in personam against you to be valid. However, in rem is different. Service in another state and proceedings in rem. Okay, now let's get back to the definition section here. Let's take a look at what do we have for, again, in rem. So we did in personam, now in rem, remedies. This technical term is used to designate proceedings or actions instituted against a thing, in contradistinction to personal actions which are said to be in personam. Proceedings in rem include not only judgments of property as forfeited or as prize in the admiralty, meaning if you take a ship a prize, or the English exchequer, which is now in American jurisprudence basically the chancery courts, but also the distinctions of other courts upon the personal status or relations of the party, such as marriage, divorce, bastardly, settlement, or the like. Now, there is a whole bunch of various different parts of that first definition that are important. Okay, instituted against a thing. That's an in rem action. What is the thing? That's called the res. What are they doing in these private for-profit courts? They are bringing judgment against all of us, against the thing, which is our estate. Okay? They never have personal jurisdiction over any of us. All they're doing are in rem actions against the thing, against the estate. As it says, proceedings in rem, including not only judgments of property as forfeited. So how have you forfeited your estate? You're presumed dead. You're presumed an infant. You never come forward to claim it. So they just do whatever they want to your estate, right? And this other second part is extremely important. But also the decisions of the other courts upon the personal status, right? Why is it so important to correct your status with the Vocational Science Freedom Status Docs? It's because once you do so, they can't use all these presumptions against you to take jurisdiction in rem against your estate because it's not forfeited. Your status is corrected. It's not considered a bastardly proceeding that you don't have any claim under the common law as a bastard to hold title. All of these things are wiped away once you've corrected your proper status. And not to put too fine a point on it, just to skip back up as we covered a few classes ago, under the definition of legal fiction. I'm going to read this again. So, for example, where a court cannot exercise in personam jurisdiction over a defendant, it can bring that defendant under its jurisdiction via quasi in rem subtype 2 jurisdiction. That's attorney speak for we're going to administer your state for your entire fucking life because you're too stupid to understand what we're doing. You never challenge jurisdiction. You never make claim. You just wander in there. You become the trustee of the little trust that they create, which is literally the court case itself. It's a constructive trust because they don't know who owns anything. They're just administering it under a quasi in rem subtype 2 jurisdiction because of all the presumptions, right? The latter is a form of personal jurisdiction that uses a defendant's property to satisfy a claim against him. What's the property? Your estate. And is a legal fiction because it treats the owner of the property as a defendant, although the subject of the suit is technically the property itself. Make sense now? See what they're doing? Every single case that you go into with these private for-profit courts, this is what they're doing to you because you're not realizing that this is all about your will. It's all about claiming your estate. And it's all about the difference between knowing what an in rem action is and what a in personam action is. And that they're doing all of this shit to you in rem. Okay? So, back to the treatise. The service of process in a state other than where issued has effect and validity only in proceedings in rem, and has more justification than constructive service by publication because it gives actual notice. We talked about service of publication before. That's where if you can't find someone or actually serve them, that you do service by publication in a newspaper. but I don't want to rehash that. But just as a short, that's what that means. Okay, to continue. A state may subject property situated within its own limits and owned by non-residents to the payment of the demands of its own citizens. The exercise of this jurisdiction in no respect infringes upon the sovereignty of the state where the owners are domiciled. Get it? Everything of what they're doing doesn't infringe upon your sovereignty. Because it's all by presumption. You agree to all of it. You don't claim your estate. It sits abandoned. And as it says, it doesn't infringe upon the sovereignty of the state where the owners are domiciled. Because they consider they consider the estate to be sitting somewhere. And where is it sitting? By presumption, it's sitting in D.C. Okay? And we'll get into that very, very important aspect of how it's there and the difference between this. Actually, it's right here. Okay, so this note is extremely important. So let me go over this. And let me make this very, very plain to everyone that they lay this out actually in the United States Code. And I hope everybody can see this, but I'll just read it. Now, this is 18 U.S.C. subsection 4108. Now, 18 U.S.C. is the quote-unquote criminal title of the United States Code. Now, technically, Title 18 has never properly been put into public law. Technically, it's just public policy, but let's just leave that aside for a second. Because what they're going to say in here, you're going to learn this difference about this understanding of what the different states are and that you have to consent and all this. Okay, so what does this say? Verification of consent of offender to transfer to the United States. A, prior to the transfer of an offender, so who's an offender? Someone who's offended or gone against the statutes or the codes, right? To the United States, and that means the District of Columbia, the fact that the offender consents to such transfer and that such consent is voluntary and with full knowledge of the consequences thereof shall be verified in the country in which the sentence was imposed by the United States magistrate judge or by a citizen specifically designated by a judge of the United States as defined in section 451 of Title 28, United States Code. The designation of a citizen who is an employee or officer of the department, let me restate that. The designation of a citizen who is an employee or officer of a department or agency of the United States shall be with the approval of the head of that department or agency. What did I say before? What's the presumption? That you're federal personnel. What does the United States have to do? Oh, just, have the approval that they can do whatever they want to you, right? B, the verifying officer shall inquire of the offender whether he understands and agrees that the transfer will be subject to the following conditions. 1, only the country in which he was convicted and sentenced can modify or set aside the conviction or sentence. By any proceedings seeking such action may only be brought in that country. Right. So what country are they talking about? They're pulling you out of your country and they're sticking you in the United States. That's what's very important about the definition of in this state. When you look at the definition of quote unquote in this state, in all the statutes, in all the state statutes, go look it up. Go see what it means. It means in the District of Columbia. So when you were traveling by common law right down the roads and highways, which belong to the people, and some Walmart clown in a outfit with little flashy lights pulls you over, what is he doing? He is literally presuming you to be in this state, meaning under the jurisdiction of the District of Columbia. That's not a joke. I'm not fucking kidding. Once you break down all the statutes and look at this shit, that's what they're doing. Number 2, the sentence shall be carried out according to the laws of the United States and that those laws are subject to change. That's attorney work product doctrine for you. And what is that? That the attorney will change whatever they want to based upon market conditions to extract as much as they possibly can out of your ass. Number 3, if a United States court should determine upon its proceedings initiated by him or on his behalf that his transfer was not accomplished in accordance with the treaty or laws of the United States, he may be returned to the country which imposed the sentence for the purpose of completing the sentence if that country requests his return. Well, is the state of California or the state of Wisconsin ever going to request your return? Not fucking likely. However, if you're lawfully domiciled and you're a de jure state citizen, where does the sovereignty reside? Resides in you. So you can demand it yourself if and only if your status is corrected. Number 4, his consent to transfer, once verified by the verifying officer, is irrevocable. Get that through your fucking head. Once you consent, it's done. You don't get to go back. You understand why it's so important to make sure that you always, always, always object? And object on these grounds. Specifically say, objection, Your Honor, I object. I do not consent to the transfer. He says, what transfer? The transfer stated in 18 U.S.C. subsection 4108. I don't consent to the transfer. Do you understand, Your Honor? The court's going to move for immediate fitness hearing. That's what you'll get. They'll try and call you crazy because you're just specifically bringing up the law that says you have to consent. And if you don't consent, they think you're crazy. Why wouldn't you want to take a benefit to going to jail and pay fines? That's just nuts, right? C, the verifying officer, before determining that an offender's consent is voluntary and given with full knowledge of the consequences, shall advise the offender of his right to consult with counsel as provided by this chapter. If the offender wishes to consult with counsel before giving his consent, he shall be advised that the proceedings will be continued until he has had an opportunity to consult with counsel. Right? Why is that important? Because you're being administered. You're sitting there as an infant being administered, but you also have to do it through counsel. Can't do it yourself. Infants can't hold title. D, the verifying officer shall make necessary the inquiries to determine that the offender's consent is voluntary and not the results of any promises, threats, or other improper inducements, and that the offender accepts the transfer subject to the conditions set forth in subsection whatever. Okay, now I'm basically going to stop reading this, but what happens here? Anybody who's ever walked into a court and taken a plea deal, what is the first fucking thing that judge says to you? What do they ask you? They ask, is this completely voluntary? That'll be the first thing they say. Why? Because they have to be following this. If they don't follow it, no judgment can be rendered against you. One way of getting rid of that is specifically stating to the judge at any point in time, I do not consent to be subject to this court nor these proceedings. And the transfer is not voluntary, Your Honor. And if he actually brings judgment against you, you can specifically say, I, Your Honor, respectfully decline your offer of contract. Because that is all it is. It is simply an offer of contract from Walmart. Hey, you want to go to jail for a while? It's all contractual. It's all by your consent. Yeah, you want to? Okay, just sign here. Right? That's what they're doing. And if you don't consent, they don't have jurisdiction. Specifically, if you make argument to that point. Right? All right, to continue. A state may subject property situated within it in its own limits owned by non-residents to the payment of demands of its own citizens. Right. The exercise of this jurisdiction in no respect infringes upon the sovereignty of the state where the owners are domiciled. It is by virtue of a state's jurisdiction over the property of a non-resident situated within its limits that its tribunals can inquire into that non-resident's obligations to its own citizens, and the inquiry can then be carried only to the extent necessary to control the disposition of the property. Right. Problem here. What's considered the property of the state? Oh, your body. Right? So they're going to pot your body to draw money off of you whilst you sit in another jurisdiction. That's what they're doing. It's all about money. Jurisdiction is acquired in one of two modes. First, as against the person of the defendant by the legal service of process. Secondly, by proceedings against the property of the defendant within the jurisdiction of the court. Remember what I said here? Remember the thing? This thing? Via quasi in rem sub 2 type jurisdiction? That's what it is, right there. Constructive service of process as by publication and service on the person of the defendant in another state are effective only in actions which are substantially proceedings in rem, again, against the thing. The force of such service is thus stated by Justice Miller in an attachment proceeding. Quote, if there is no appearance of the defendant and no service of process on him, the case becomes, in its essential nature, a proceeding in rem, the only effect of which is to subject the property attached to the payment of the demand which the court may find to be due the plaintiff. Just to make a side note about this, this is why it's so easy to get a default judgment in federal court if it's only money. If you don't believe me, you might want to go read the Federal Rules of Civil Procedure. It is ridiculously easy to get a default judgment in the federal courts if it's only for money. Why? Because this is why. Okay? To continue. That such is the nature of the proceedings in the latter cases of class of cases is clearly evidenced by two well-established propositions. First, the judgment of the court, though in form a personal judgment against the defendant, has no effect beyond the property attached in that suit, as we were just talking about. No general execution can be issued for any balance unpaid after the attachment property is exhausted, meaning they can't come find you in another state for, oh, well, you still owe us money. Why? Because they don't have jurisdiction over it because it's not there. No suit can be maintained on such a judgment in the same court or in any other, nor can it be used as evidence in any other proceeding not affecting the attached property. Nor could the costs in that proceeding be collected of defendant out of any other property that is attached in the suit. Secondly, the court in such a suit cannot proceed unless the officer finds some property of a defendant on which to levy the writ of attachment, meaning in the state. A return that none can be found is the end of the case. Now, make a side point on this that I didn't even think about until I just read that again. A return on that none can be found is the end of the case. Guess what? You do your Vocational Science Freedom status doc set properly, and you go and serve every single agency that's out there, meaning all of the agencies that keep track of this wonderful thing called your debt reliance, or how good of a boy you are paying your bills, otherwise known as a credit score. If you serve every single credit reporting agency with the Vocational Science of Freedom status doc set, and they literally have to remove you from their records, this is what you're going to get. Every single time a court tries to, any single time that any of these private for-profit courts try to charge your estate with something, this is what they're going to get. A return that none can be found is the end of the case. Why? Because they can't find any way to attach your credit, to attach the estate to the case itself. They won't touch it. There's no way they could touch it. And the way that they do go about touching it, in the way that before you do that, before you get rid of it, is that they do it by power of attorney, which we've talked about many different times as to how they create the bonds. They create them by power of attorney so that they can then charge your estate. Okay? So anyway, just a side note on that. And deprives the court of any further jurisdiction, though the publication may have been duly made and proven in court. Can't get to the res? None can be found? Done deal. That's it. That proceedings in rem may be maintained and rendered effective in one state by the service of process on the defendant in another is a declaration that expresses a principle of general, if not universal, law. Decrees in actions for divorce based upon such service are sustained on the theory that they are proceedings in rem. Because what's marriage? Marriage is a three-party contract. You, your spouse, and the state. What is the res of your marriage when you're entering into that contract with the state? The production of your marriage, what is the res? It's your fucking children. Think about that for a second. So that's why it's all in rem, folks. And it says right there in your face, decrees and actions for divorce based on such service are sustained on the theory that they are proceedings in rem. You're a thing. You're a human resource. That's how they're doing this. It's all commerce. But there is high authority against the validity of such service and actions for divorce. Yeah, but they're still doing it like that. Okay. Seeing as how we're getting to the end of the hour, I was going to try and work in another chapter, but this is fairly big chapter. And even though I only put little parts here and there into it, I think I will save this for next time. So I'm going to make a note here that this is where we can restart again. So I'll start here at class 8. And is there anything that anyone wishes to bring up in chat or voice your opinion about? I'll make sure that you guys are unmuted.
I have a question.
Yeah.
What would you do, because I have a marriage license, what would you do with that? Would you take your doc set and send it to that county that has it recorded, or what would you do in that case, marriage license?
If you wanted to remove and get rid of the marriage license, it's much easier to do so if both parties want to do it together. I've written documentation for someone to do that, specifically stating that at the time there was no meeting of the minds, meaning the state said, you have to go do this. Here's the marriage license contract. But they never explain, the state doesn't ever explain that it's literally a contract with the state and what that implies. And so therefore, into entering in the contract, there's no meeting of the minds because you had no idea this was going on. And so I wrote a document specifically stating that, and then both parties sign it, and then they would serve it upon the county of which the original marriage license had process of done. And then if they don't recognize it, you could then sue the county to say, I demand that that we be removed from this contract and that it be considered to be void ab initio for the reasons stated in the notice.
Okay.
And that could be done simply as it would be a judgment, because you wouldn't be looking for damages. It would simply be a declaratory judgment. And a declaratory judgment is the one that you seek from the court. And all a declaratory judgment states is that the relationship of the parties. So it would state, the declaratory judgment would state that the state of Pennsylvania has no interest in such and such marriage of these two people, and so on and so forth. And you would write it up to state that, so that they couldn't come in and claim the children or do anything else that they try and do in these private for-profit courts, because there's no original contract of which allows it to happen. Because, and this is kind of a what comes first, the chicken or the egg thing, it's through the marriage licenses that the whole entire idea of the children being property of the state and being a res, meaning being a product of the marriage, is kind of where it starts. However, you could also consider the same thing to be from the birth certificate contract, that the child gets registered with the state through the birth certificate contract, gets abandoned at the foundling hospital, a foundling being a child being of unknown parentage, lost or abandoned. That's a foundling. And all these hospitals being foundling hospitals, that's how the original presumption starts. So is it that, or is it the marriage contract that creates the child as a product of the marriage and as a res, literally, to be controlled by the state in an in rem proceeding, as we just saw regarding divorce? There's argument to be had both ways. But to answer your question, that's what I do because of those reasons. It's a contract. There's 3 parties to it: you, your spouse, and the state, and it needs to be abolished. And I can get you paperwork. You can just hit me up on Revolt or message me in Mega, or you can send me an email, and I will be happy to dig that up for you and send it to you.
Can I ask a question about that?
Sure.
So if it's void ab initio for the reasons that you said, that you mentioned, that it's not, you didn't have a proper meeting of the minds, I mean, do you really need the court to approve of that if you write it out and you put your evidence, I mean, there's not really any evidence. You're just claiming that there was no meeting of the minds, and that's it. I mean, you just kind of serve it to them. It's on the record. You really need to wait for them to tell you it's no.
No, you don't
And
need to, you're not waiting for them to tell you anything. By operation of law, yes, you are correct. It is void ab initio. However, the presumption will remain in full force and effect that the state has the capacity to come in and determine what is the husband's, what's the wife's, what they're going to do to the children based upon the contract itself until it is rebutted, because there's rules in state courts and federal court too, I believe, that state, and I'm going to paraphrase this, state that basically that the presumption is in full force and effect until evidence is produced to rebut its non-existence, which is a weird way of saying that we're just going to hold you under the presumption until you prove us wrong. Well, that's the way you have to prove them wrong. You have to process serve them documents saying, I do not consent to this contract. It's now null and void. And only one party really need do this. It's not necessary that both parties, both the husband and the wife, do it, but it sure as hell carries a lot more force when both of them agree to it. So yes, you're right. It is void ab initio, but the point that they're just going to run roughshod over you by the use of the presumption, unless you rebut it, is the problem. So you have to do that.
Okay, wait. The presumption is to do with the children, though, not the contract. If the contract is void ab initio, that's it. I mean, you brought it up. You said, hey, okay, there's fraud.
But it's not void ab initio. Well, it's void ab initio only when you do bring it up. Only when you say, hey, there was no meeting of the minds at the time. Therefore, this contract is not by my consent because I never knew what it entailed. And unless and until you bring up the argument, unless and until you bring it up, they're just going to continue to see the contract as being valid. That's the point.
Yeah, but my point was still that, like, you just need to bring it up to the state, probably the Secretary of State or something, to have this notice process served, and just inform them that you've realized there's a fraud or that there was a mistake in the contract because there's no meeting of the mind. That's it. They don't even really need to reply. It just needs to be maybe process served so you know that some agent of the Secretary of State is.
No, you would want them to take action. If they don't take action, then there's no point in sending the notice. So you demand within the notice that they take action, and then that they send you some sort of proof that they have removed this contract and that you are not any longer being subject to it. If they don't do that,
removed it off the record, off their books or whatever.
Sure. Yes, they have to correct it, because if they don't, then it's still there.
What's nullifying a wedding? Yeah, nullifying a marriage?
Well, nullifying would be any other reason. I mean, that's one reason as far as, but you're talking about a difference between a marriage and a marriage contract. A marriage contract is different than, say, the marriage itself, because two people can get married on the top of a hill with plenty of witnesses and a priest of their choosing, and they're properly married as per the law of the Bible and as per the common law. And particularly if they stay with each other for 10 years, then they're common law married anyway. But a marriage license, which is this thing that's between you, your spouse, and the state, is a different matter altogether. But you're saying what can be some other reasons why a marriage would be nullified, you mean? Is that what you're getting at?
No, why can't you decide with your partner to nullify the marriage?
That is what you're doing.
Well, it's nullifying the license in the state's intervening of the contract to have authority over us and the children, right?
Exactly. You're not nullifying your marriage between each other. Right.
Yeah. I don't want a divorce. I'm still going to stay with my husband. Him and I, my history is I've been in jail for 30 days because of homeschooling reports. All because of that marriage license is what I'm gathering?
Yeah, you got it right. Yeah, that's it. The state has control over your children because you have entered into a contract of which the production of the marriage ends up in children. Yes, that's in a nutshell what they're doing. And the fact that you also register the children with the birth certificate contract, which is why you have to do your Vocational Science Freedom status doc set to remove the children, if they have not yet come of full age, out of the system, claim them as part of your estate, and say you do not have consent to administer them any longer. But again, if you don't do that, the presumption stands. The presumption stands that they've been abandoned at the foundling hospital. The father never came to claim them. They're considered to be wards of the court, wards of the state, and those presumptions will stand, and they will continue to criminalize you for the incorrect use of property of which no one's claimed. And that is all that they're doing. That's it.
Gotcha. Yeah, I was wondering. Like, I stood in the courtroom saying I don't consent to these proceedings, and I am the lawful mother. My husband stood right next to me, and we just said, we stood there honestly, and we're like, "Where's the meeting of the minds? Where's the contract that has us even in this courtroom?"
Well, they're not going to want to produce that, but technically you know where it is. And
well, now I
also
have
another good thing about the Vocational Science Freedom Status Doxa is that once you do it, you are entering into an entirely different form of contract, but only in between you and your spouse, and your law is that of your own domicile, is that of your husband's house. He comes over and protects you with the law of his domicile, with the law of the house, of which you willfully enter into and be under the protection of. And once that's done, you're assigning him the executor position of your estate. So if anybody ever tries to administer your estate, he can come into that in rem proceeding and say, I'm the executor of the res of which you're attempting to administer, and I do not consent to its administration. And here is the contract, and so on and so forth. And my friend, there's been friends that I know that have done this. They have their Vocational Science Freedom Status Docs done. Their wife got pulled in for some damn thing. I think it was a debt issue. And the husband came there as the lawful executor of his wife, and the judge completely went along with it because he put the status docs into the court case.
Gotcha. So, is there a statute of limitations, like, because on, like, what they did to me? Like, is there a limit on when I can seek
No, because it's all
remedy?
based on fraud. Fraud, as I read today, fraud destroys
Yeah,
everything. Fraud nullifies everything. So otherwise, in a sense, there would be a statute of limitations, but any time that fraud comes into the situation, there is never a statute of limitations because fraud destroys everything. It's void ab initio. And as long as you bring it up, that at the point of time of which you do so is when it nullifies it, but not until then. So just know that. And that goes with everything else that we were talking about tonight, going over regarding the argument of anything that you get served, or that you have an argument for incorrect process, or that you're trying to get pulled into another state, so on and so forth. If you don't make the argument, you consent. If you don't object, you consent. That's, in a sense, the bare bones minimum of it, that you should all remember that simple rule. If you don't object, you consent. And it's by your own will. So that's why it's important to do that. So, okay. So any other questions anybody else had for tonight?
I don't have any questions, but I'd like to mention that my wife and I, we created our own birth declaration and our own at-law matrimony declaration, and we haven't had any issues with the state anymore. And they actually, our at-law declaration of matrimony, they put it in the marriage certificate section of the public record, which was pretty interesting, and they've totally acknowledged it.
Good. Excellent. That's exactly what you should do. And for anybody that has that information, I believe you put that. Did you put that into one of the committees, or have I not read that yet? I think I have.
It was back when we were on Gilded. I put it in there.
Okay. I might have still had it in the mega file for one of the committees. I'd have to go back and check, but if you could make sure just to email me that again, so it can come to my forefront of my attention, and I'll make sure that it is, and obviously redact it, but so we can put it into a committee so that everybody can use it. Because yes, after you do so, yes, you do have the Vocational Science Freedom Status Docs done, which I know you did. But on top of it, it is good to just have a certificate to say, look, this is what we're now agreeing to, and give it to them in a juristic act of which they can recognize. Because yes, you do it by contract in the status documents, but technically it's only an executor appointment. It doesn't really say marriage contract in the Vocational Science of Freedom status docs. It's just an executor appointment that then the husband controls and makes sure that he can protect the res of his wife's estate. But to put that on top of it, what you did pretty much is the final nail in the coffin, if you will. It's basically finishing your process.
Yeah, and what we actually named it, it was a declaration of at-law matrimony by will and testament. And I had it served on the judge and the sheriff and recorded it, obviously, and had the certified copy served on them. And after the judge, the next day after he was served with it, he was like, hey, he like waved me down one day when I was at the grocery store, and he was like, congratulations. So it was pretty interesting.
That's
how
cool.
they
Right. That's great. Yeah, because in a certain sense, they don't want to be in a position where they're going to attempt to administer something that someone has come of full age and is taking care of their own affairs. They don't want to play daddy anymore, nor should they be doing so anyway to begin with. But they will definitely congratulate you when they see that you're doing what you're supposed to be doing. And I've heard that a lot. But that's just another good tale of that going on. Yeah.
Yeah,
Bill?
just to show that it works. I mean, it was put on the public record, and the clerks acknowledged it, the judges acknowledged it, the sheriff has acknowledged it. And we actually just recently sent that with a new passport application to get her last name changed. And, you know, we're totally bypassing the courts and everything. And I also found some case law that says at law, there's no need to go through the courts to get your name changed. So we basically did it through will, and yeah, I'll keep you updated with that too.
Yeah, precisely. And that's exactly what you want to do, particularly before you have a child. So you got all this stuff out of the way, it's on the record, it's finalized, and your child is protected. It's not going to be subject to the jurisdiction of the state.
And that's exactly what we did. And we also did his birth declaration after he was born, and did the same thing. We sent in for a passport with all of our stuff in the Bible that we put in the family Bible, and then the declaration of free birth that we did on the public record too. So yeah, that's a recent development. We just sent that out a couple of weeks ago.
Good. Yep. You're doing your due diligence. You're doing exactly what we should all do as sovereigns, as American sovereigns, keeping our own records, taking care of the business of our own houses to get our own houses in order, and make sure to give notice by process service to everyone that might think otherwise. That is exactly what we should be doing.
The last thing that I have a problem with is the payment of the fees that they want from me for paying to have my documents publicly recorded.
That's true. There are ways around that, and I have told stories in previous classes a long time ago about a gentleman who went to go have his recorded. I believe it was in Michigan, and he got to the public recorder, and they were giving him, well, you got to fill out this, you got to pay this fine, pay this, that, and the next thing. So he calls me on the phone, doesn't tell me that I'm on speaker, and then summons the actual clerk of the county recorder, to the front desk. And so he's in earshot of what I'm saying. He then proceeds to tell me what they said. Well, you know, they're doing this, and they're saying I got to pay for that and whatever else. And I said over the phone, in earshot of said public trustee, demand that he produce the law upon which he relies to deny you access to the public record. The second I said that, the public trustee tapped the other clerk on the shoulder and he said, record whatever they want, no fee. And he basically ran back into his office and wasn't seen again for the rest of the day. And he then proceeded to file his doc set, his wife's doc set, and then sat there while they then printed off 7, and you guys know how big the doc set is, 7 copies, of which he made sure were all then on the record, and that they wrote on the top of it that this is a certified copy.
Yeah, they handed me
For no
whole
charge.
bunch of statute and code paperwork showing why we have to pay.
Again, that's not
supposedly
okay, but that again, that's aspects of, oh, this is why you have to pay. And I'm sure in all of that statute and code nonsense, it said that a person must. You're not a person. You're one of the people
Right.
of one of the several states of the union. And he already explained that to the trustee and said, you're my trustee and I'm one of the people of Michigan and so on and so forth. He already had that conversation prior to the telephone call. So that was already established. Now, the amount of rigmarole and nonsense that you're going to have to deal with regarding public trustees can be a little, it can be a lot. It can be so over the top that they'll never do it. My suggestion to everyone is find a county that's not quite so communist and record it there, because it doesn't matter where you record it, because all public records shall be acknowledged by every other state. So that's a federal constitutional issue of which they cannot get around. So it's nice to do it in your birth county. It's nice to do it in the county of your domicile. But if either of those two are acting like idiots, simply go someplace else. And I know that there are a couple of counties of which are listed actually in the Vocational Science of Freedom Revolt server. And in such, I believe we have them under county recorder, friendly county recorders, I believe is where we have it right here. Yep. See, friendly county recorders. It's in, and if everybody's looking here, this is on the Revolt server. So you join the Revolt server by going through getting your welcome package done and sending to me. And then you come in and I'll find you in the landing pad and then just message me. Make sure you become friends on here. And then I'll see that you did your welcome package. I'll read it and I'll let you in. And then afterwards, you go to friendly recorders offices. These are all of the ones that we found when we were back on Gilded. And none of these have any problem with recording the Vocational Science Freedom status doc set. Okay. So, yeah.
I don't know you're going to talk about me, but I was just going to say regarding this, that when I was trying to figure out the most economical way, when I was basically dirt poor, was through Pima County. Because like what we had talked about, I guess in the group on Gilded, was that each individual component was, or it was like $1 a page or something to other places. But when you combine the entire doc set, it's $33. So
Well, there you go. Right.
It saved a whole bunch of money.
Yep. And so that's the one that you gave me. That information's there. Pima County Recorder, P.O. Box, such and such, Tuscan, Arizona, all that, and $31. Done deal for the whole set. So anybody got a problem with it for money wise, go there. They're also the other one. I think it's okay. So we've got Lebanon County, Pennsylvania, and then anyway, they're all here. So the ones that we found that are good are here, and obviously that one's the most least expensive. So I believe there was one from Georgia that actually you could look up your doc set after you filed it online, and you could actually get a link so that other people could view it online as well. Now, granted,
you can do that in Pima County too.
Oh, you can. Okay, great. Now, granted, that doesn't count as service, everybody. So don't think that I'm saying that, oh, you just send them a link and that's service. No, I'm just saying that if you want to have it instantaneously available for someone, say like on the side of the road, like a cop or something or whatever else, you say, here, this is where you can go read all of them, even though you've already been served with it, kind of thing. Because to properly rebut the presumptions, they need to be served. Okay. But yeah, so there you go. All right, cool. All right, everyone. I think we'll call it for the night. Thank you, everybody, for your comments and your questions. And thank you, everyone out there who's listening. This has been the Vocational Science Freedom, our reading of the treatise on Dueprocess. I will continue to read from this until we're done. I'm going to skip through a lot of it, as we have been doing, to make sure that we get through it quickly. But we're about halfway through. And as a side note, one more thing, I'm going to make playlists of all of the treatises of which I read from, so that when you have to look up some specific aspect of law and I've read a treatise covering it, all you have to do is go back to the playlist and learn it. So I hope all of you have a wonderful rest of your weekend. And until next Saturday, as always, stay safe and stay sovereign.
Oh, say can